On August the 7th, 2025, the BC Supreme Court made a landmark decision that sent shockwaves across this country. Not only did the court determine the ownership of several hundred acres of land in Richmond, BC, but it said, according to the court, that wherever Aboriginal title exists, it is prior and superior to your property rights. And therefore, the question is, does that potentially put into question your property rights? What better person to talk to about this very important landmark decision is my friend and senior fellow at the Frontier Center. He's a professor of law at Queen's. He's also the executive director of Rights Probe, is Bruce Pardy. Welcome, Bruce.
Thanks, David. Nice to be with you.
So, Bruce, we have been having quite a number of conversations about this landmark decision, and you have been certainly making your analysis known across this country. And I would say bravo to you. As I look at this decision, the question is, is this a landmark decision that has the potential to put everyone's property rights in this country in question?
Potentially, yes. Here's some qualifications. So first, this is a decision of the BC Supreme Court, so that means it's a trial level decision. So it will still has yet to be appealed, and we'll hear from the Court of Appeal and maybe the Supreme Court of Canada. We will see. So this is not the final version of this decision, but as it is written right now, yes, it is groundbreaking. But the second qualification is it is groundbreaking, but along the same path that we've been on for a long time. One could have predicted that this is where we might end up for a whole host of reasons, which we can get into. But as you have mentioned, the key words, I think, in this decision are senior and prior right. The Aboriginal title is a senior and prior right to fee simple. That means that where a claim for Aboriginal title is made and found to exist, the property in that area, whether it is publicly held or privately held, the title to that land is secondary to the Aboriginal title. And people in Richmond are finding that out right now, and what potentially all the implications of that are. But we started to go down this road decades ago. For example, when we put in the charter in the new Constitution, right? So Pierre Trudeau's original draft of what would eventually become the Charter of Rights included a right to property. But when the charter was actually put into being in 1982, that guarantee had been taken out at the request of some of the premiers, including some of the Western premiers. And at the same time, what was put in, going back to this first draft that Trudeau did, that first draft did not mention Aboriginal rights. But sort of at the last minute before the Constitution was patriated, there was a campaign put on to include Aboriginal rights, a guarantee to them, in the Constitution, which, in fact, that campaign was successful and it was put in. So here's what we ended up with. No property rights except for Aboriginal title rights. And so the constitutional right in Section 35 of the Constitution is now a constitutional right, and nobody else has a constitutional right to their property. So the government can expropriate your property, take it away, and if instructed to do so by a court, can be taken away and given over to an Aboriginal group that makes a title claim. So your fee simple title in your land is secondary to the prior and senior right of Aboriginal title in those areas where such a claim could be made. And this is going to be a big problem in BC, especially because the land in BC is not subject to treaties for the most part. And so most of the territory of BC is going to be open to question in this way. But it's not just British Columbia. These kinds of claims have been made in New Brunswick and in Quebec and so on. And so the book is not closed across the country on this, and we're just going to have to wait and see what all the fallout is, and it could be considerable.
All right, so there you have it. the summary from Bruce Pardy on this very important decision. So we obviously want to tread carefully through this topic because we know that this matters to every Canadian about whether you just don't frankly own your home, but your business, and whether this really, frankly, takes the quote effort of reconciliation to a whole nother level. And really, I believe, Bruce, and I have a confession to make. I actually read the full decision over the last 3 weeks, and because we had our initial conversation with another great legal mind, Bruce Halser.
Right.
And I've certainly been in contact with others here at Frontier, like the former judge Brian Giesbrecht. But the analyses are really quite disturbing, and it was an eye-opener for me to read that decision. I see it, from my limited perspective, as truly, if it stands, as precedent setting. And I think it should send shockwaves across every Canadian's mind as they look at this issue. So I want to look at not only the significance of the decision, but basically the origins of it, how we got here. It wasn't just overnight, but clearly, are there remedies that we need to pay attention to, as we obviously share a vision that all Canadians, including Indigenous peoples, we live together in peace and we build prosperity in this incredible country. But this decision is very concerning. And so my question is really simple. Were you shocked by the decision, Bruce?
No. Well, let's put it this way. It's shocking, but not surprising. I mean, the where we're at is now shocking, but it's not a surprise given where we've been and the road we've been traveling down. I mean, the Supreme Court of Canada for years has been expanding and evolving the meaning of Aboriginal title and rights as guaranteed in the Constitution. So Section 35. So this is one of the mistakes that's been made. Section 35 at the time was not intended to be an expansive, ever-growing set of rights. It guarantees the existing Aboriginal rights as of 1982 when it came into being. But it hasn't remained that way. The Supreme Court of Canada has taken the words in that section and discovered things that have always existed. You know, this is the way they would put it. And because Section 35 is not in the Charter itself, it is not subject to the notwithstanding clause. So provincial legislatures and Parliament cannot legislate around it or through it or over it. It is solely within the control of the courts as to what this means and what its implications are. So the only real remedy to this, given the determination of the courts to go in this direction, is to repeal Section 35 of the Constitution. Now, as everybody knows, we have an amending formula in our Constitution that is very demanding and very difficult to satisfy, and the prospects of doing that in the present day are essentially nil. You would need a collective political will to do that and to overcome the vested interests that have stakes in having things the way they are, and you know, we're nowhere near that at the moment.
Gosh, it's hard to believe that we've come to this point now where this issue surfaces publicly, and I think people are starting to realize the significance of it. The decision has been appealed by the province of British Columbia, the city of Richmond, among others, including other First Nations that have kind of competing claims.
Right.
And what's interesting is that the city of Richmond just the other week called a public meeting because they originally wanted this whole court matter to be known by the public, but the court instructed not to make it known. And I'd like to get into that in a moment. Hey, show the channel some love. Hit that like button, leave a comment, and subscribe. It helps us reach more Canadians who need to hear this. There's a ton of great conversations right here to help you think deeper and stay informed. So stick around. You'll be glad you did. The point is the city of Richmond called a meeting of the area property owners and said, hey, this decision's been made. You need to be aware of its potential impacts. And now we have homeowners that can't get mortgages. They can't get mortgage renewals because this Their titles are now under legal dispute, under question. So there's a lot of uncertainty. So I wanted to share this clip with you that comes out of the aftermath of a larger public meeting.
On number 6 Road in South Richmond, a loan for sale sign in front of one of the properties that's part of the Cowichan Nation land claim. It begs the question, if they've got a buyer, would the deal proceed as usual? A canvass of the neighborhood Friday revealed some residents were confused about the status of their properties following this summer's court case and a recent letter from their mayor. 88-year-old Paul Wojtowicz told us he didn't know if he could now sell his house without the First Nations approval.
I would have no idea if it's legitimate, if I can do it on my own or not. That's the very big question right there.
I said we're going to have the same decorum. Do we have to shut it down?
That was Richmond Mayor Malcolm Brodie at his recent information session. Tense and well attended, the confab was meant to provide clarity on the issue. But that, plus a blizzard of conventional and social media, doesn't appear to have helped much. But Friday, our question to the Ministry of Attorney General got this response. There is no change to property sale procedures. It is important that people continue to be able to buy and sell freely and access mortgages, they wrote.
The courts remain an option for First Nations.
Global News reached out to the Cowichan Nation Friday to get their understanding of whether property sales in the claimed area will proceed as in the past. But we didn't hear back in time for this story. Details about the situation there are being followed closely by people across the province, according to pollster Shachi Curl.
They see it as potentially sweeping, serious, in that it could have a broader impact on private property rights in the province.
Back on number 6 Road, assurances from Victoria are welcome, though not necessarily comforting in the middle of the night.
It's not a good feeling at all in the morning to think you could lose your house here or become worthless.
In Richmond, Paul Johnson, Global News.
So people are still waking up to the reality of this decision, and it's not entirely clear. So I want to make that clear, that there are known unknowns here and many unknown knowns, as they say in logic. But Bruce, are you surprised that some people are not getting mortgages on their properties in the land in question now?
I wouldn't be that surprised because there is now a degree of uncertainty about what the situation is. So in that story that you just played, it's interesting that it was important to ask the Cowichan Authority whether or not the sales could go through. Now, they didn't get an answer, but the point is they had to ask the Cowichan Authority, yes. Right? And that is the implication of the decision. The decision says in black and white. Let's go back to the basic point. The decision says Aboriginal title is a senior and prior right to fee simple. That means it comes first. And
wow.
And if therefore, if your piece of property is within a territory which a court decides is subject to a valid land claim, then Aboriginal title comes first. Now, what happens after that? We don't know about that. Is it just the fact that someone's going to come in and boot you out of your house? That's probably not likely. Is it the fact that the government, and this is a suggestion that a New Brunswick judge made in a similar case that didn't quite proceed as far. It's not at a final stage, but a New Brunswick judge has said that if, in fact, a land claim is found to be valid in an area of privately held property, then the court could instruct the government to expropriate your property, to hand the title over, and then compensate you for the value of the land, right? So we don't exactly know what's going to happen here, but the bottom line is pretty clear, which is there is, in the case of Richmond, definitely, but in other situations, possibly, a prior and senior land right to the fee simple that you hold in your home.
Wow. That's amazing. So people are starting to wake up to it, and you saw in the clip there the president of the Angus Reid Institute, and there's a slide here that shows the kind of the opinion polls of the concern that are happening now in the area. And it's interesting. This poll was taken before the public meeting, so it's just starting to become a little bit better known here. And it says, based on what you have seen or read or heard about, including the survey, do you think the court decision is significant? I believe that's the wording.
Mm-hmm.
And of course, you've got a significant percentage that are increasing their level of awareness. Well over half are very concerned about this issue. So we have a situation here where it's just people are just starting to wake up about the significance of the issue. And I guess one of the things I wanted to look at here, Bruce, with your kind expertise, is help us understand what we mean by the fee simple property system
Sure.
versus the Aboriginal rights system, and can they coexist? It seems
Right.
like you've hit the nail on the head that if you have prior and superior rights of Aboriginal title of land, how can you also have your property owned by yourself at the same time?
Right.
Help us understand what this means.
Yes. Okay. It's a very good question. So fee simple is the highest form of private property you can hold in our common law property system. If you hold fee simple, then you hold as much property as you can. That does not mean, and has never meant in Canada, that the government can't take it away, because we don't have a constitutional right to property. So, for example, in every province across the country, there is an expropriation statute, and that provides a method by which the government in question can take the title to your land and pay you compensation as described in the statute. So it has never been the case that your property is absolute. The crown, holds the land underneath your title, and your ability to keep it depends upon the government and the authorities deciding to leave you alone. Mm-hmm. Even that might be a shock to some people. But Aboriginal title is a different kind of property interest altogether. The Supreme Court of Canada has called it sui generis, meaning it's not like the other things. So these two interests are in different systems of property. Mm-hmm. And Aboriginal title is a kind of communal right that the Supreme Court of Canada has described in some detail. It's a communal right. It does allow the group to control the use and occupation and so on, but there are also limitations on the use to which the land can be used, because it is communal, is held by the group, and therefore must be preserved for the group through time. Aboriginal title can be surrendered, but it can be surrendered only to the Crown. In other words, you can't sell Aboriginal title to some other private person. Mm-hmm. It is dependent upon the relationship between Aboriginal groups and the Crown, and that's the only entity to which that title can be transferred. Mm-hmm. Aboriginal title and fee simple private property are incompatible. You cannot have both coexist on land. Even though we're now suddenly, just in the last little while, with respect to this decision, but also with respect to some agreements the BC government has made, which we can talk about.
Yes.
There's a pretending going on now that these two things can coexist. But the nature of Aboriginal title, which is communal, essentially means, as it's been described by the Supreme Court, means that no one can own the land privately. Now, mm-hmm. in these agreements, the BC agreement, for example, has made an agreement with the Haida Council to acknowledge Aboriginal title over Haida Gwaii. The whole thing. But before the agreement was made, there are people on Haida Gwaii who hold fee simple property on Haida Gwaii. Mm-hmm. And the agreement says, Well, yeah, we're recognizing Aboriginal title, but don't worry, we're also going to honor fee simple. And, the Haida Council also agreed to honor fee simple, right? So now we're in a very uncertain situation because your fee simple title to your property on Haida Gwaii is now dependent upon the council deciding to honor it through time. But in fact, they have Aboriginal title over the whole thing. So if it comes to the point, at some point, where the authorities on Haida Gwaii decide that they don't want to do that anymore, they have Aboriginal title. And so your security of tenure for your fee simple property depends now on their continuing honoring of the terms of the agreement and the existence of your title, which was there before the agreement was made. It's terribly uncertain, and it's incoherent. It does not make sense. And so people who own property in this kind of situation, like in Richmond or like on Haida Gwaii, are in a perilous situation.
That's unbelievable. So it's incoherent, Bruce, in the sense that either you own your property or you don't. It's a binary answer, isn't it?
You'd like to think it was a binary answer, but in these kinds of situations, it's not binary anymore. No, and so we can put it this way: if you like what the court has done, and in different situations what the BC government has done, is put the Aboriginal group into the shoes of the government, in the sense that they now have the power to decide if and when they're going to take over the land to which you hold fee simple.
Wow. So that's their definition of reconciliation, is that they'll separate people out according to their hereditary background, their race, and they'll elevate them to be the same as the government, the crown.
Well, see, some of the reaction to the backlash against the decision has been, from Aboriginal quarters saying, listen, this is an overreaction. Don't worry, we're not after your house. Okay? The point is that you can be after their house if you want to. You're just deciding not to. That's a completely different kind of property interest than knowing that you have security of tenure in your house. Okay? That might be true. Wow. That might be true in certain situations and from certain groups, that they're going to honor the land holdings of the people who are there in this territory in which title has been recognized. They're just going to leave them there and not bother them. That might happen. But the point is that doesn't necessarily have to happen. And so exactly. There is more. There are other interests now held by other people over the land to which your fee simple applies.
Okay, so this is where we've got to really be very clear-eyed in terms of the implications potentially of this decision, because we can't blow and suck at the same time. You either own your property or you don't. I found a paragraph 3551, you can look it up, of the Cowichan decision, and it states this. Mm-hmm. A precedent that will follow from this case is that provincial crown grants of fee simple interest do not extinguish nor permanently displace Aboriginal title, and sections 23-25 of the Land Title Act do not apply to Aboriginal title. Doesn't that hit the nail on the head?
Correct.
This is intended to be a precedent-setting decision across the land, yes, from coast to coast to coast, and it basically takes a missile on our economic system, because if you don't have property rights, how does your economy move forward?
Right. Well, right. All these things are woven together, right? Property rights are one of the things that makes the logic of your society work. And if you pull on that thread, then the whole thing starts to unravel, right? Security of tenure depends upon your ability, it determines your ability to get financing, to get mortgages, to get credit. It determines the ability to enter into commercial enterprises. in BC, 95% plus of the land is held by the Crown, and the Crown is the one that gives out permits and so on to work the land, agriculture, forestry, mining, and so on. And if the ability to use land and the security of land is thrown into question, then yes, the commercial enterprises upon which the economy depends will also be thrown into question.
Remarkable. So, Bruce, is it fair to say then we'll be the only, to my knowledge, the only common law country in this world that will have such a dysfunctional kind of system? I've never heard this before.
I haven't either. I wouldn't want to be definitive about that because I don't know that for sure. Well, so in New Zealand, for example, they have a much different kind of situation, but it's also complicated because they have the Treaty of Waitangi, which is in some quarters, regarded as the Constitution, and that creates a relationship as well that's problematic. So the details are different, but the difficulties may be similar.
Yeah. But the point is you need certainty. You need certainty in life to do many things, including own a property, to be able to not just accumulate property, but property rights in itself are, I believe, and so many others have said this over millennia, a significant check to the unfettered power of the state or arbitrary decisions by who knows whom. Like if you don't have a property, it affects profoundly the rights of your freedom of association, your freedom of speech, really everything, doesn't it?
Well, it affects everything, no question about it. But so if you like, here is one of the dark silver linings of this case, which is that Canadians may be discovering that the property interests that they thought that they held are not what they actually are. And the fact of the matter is that even long before this kind of decision came out, our property interests in this country have not been secure for the very reason that the government has the authority to take them away if they want to, right? So we have always been subject to that kind of authority. It's just that governments haven't been in the habit of doing it in a reckless way. I mean, they expropriate things to build highways and airports and things, but the political cultural climate have held them in check, not the law. If any provincial legislature wants to take your property, and they legislate that, it's not just a policy decision; it's a legislation. If they put it in legislation, and they say, and they can even go this far. So to be clear, the expropriation statutes that exist right now in these various places include a process for owners to receive just compensation for the expropriation. Okay, but that is a product of the legislation. It is not a product of the Constitution. And so, if these provinces wanted to draft new legislation that said, "We are taking your house and we are paying you nothing for it," they would be constitutionally able to do that. In fact, the matter is that in Canada, we are subject to the authority of government more than anything else. And this is just one of the functions, or if you like, consequences of that relationship. Our courts, and in fact, our legislators, this is especially the case in BC, are seeing to it that your property interests are undermined. In BC, at the same time that in the past week, the BC government has said, oh, well, this, Aboriginal title is not superior to private property interests. Baloney. That's not what you've been saying or doing for months and months. The BC government has been making agreements with specific Aboriginal groups over specific territories to either acknowledge Aboriginal title or to promise to do so in the future or to enter into, joint management schemes so that the use of land in those territories is subject to an Aboriginal veto.
No kidding. So you're saying that something else is going on here. Not only have we had a variety of of legal decisions. We have, depending on which government, like the BC government, has really been undermining our property rights.
Let's just paint this picture in BC, because BC is the worst of the lot by far. Okay, so going back in time a little bit, we have the UN Declaration on the Rights of Indigenous People. It's a General Assembly declaration.
Oh, the so-called UNDRIP.
This is UNDRIP.
Yeah.
Now, it's just a General Assembly resolution, and as that, it is non-binding. It's aspirational, and at first, Canada refused to sign on, along with Australia, New Zealand, the United States, and so on. But when Justin Trudeau was elected, the Canadian government changed its objection to the resolution and signed on. Then, the BC legislature passed a statute called DRIPA, the Declaration on the Rights of Indigenous People Act. And that act requires the BC government to make BC law consistent with the declaration. Now, here's what the declaration says. And I kid you not, this is literally what it says. Basically, it says that that Aboriginal peoples are entitled to the land which they have ever occupied, used, or otherwise, were on. It is a mandate for the BC government to do more or less what it's been doing, which is to transfer control of land in BC to Aboriginal groups. And, all the way along with this, people kept saying, you read DRIPA. When DRIPA first came out, UNDRIP itself. UNDRIP, which is the UN resolution. You read it and you think, well, they can't be serious. It's pages and pages of rights that all Aboriginal peoples are entitled to, including having it all funded by governments. And so the reaction was, well, this is aspirational. They can't really be serious. Okay? And then they passed DRIPA in the BC legislature. And DRIPA says BC laws must be made consistent with UNDRIP. And the reaction to that was, don't worry, they can't be serious about that. Okay? Folks, they're serious. The BC government has been following this mandate, this agenda now in a concentrated way for 4 months and getting to be years now. And you can see now how serious it's going to be getting. This brings us, if you like, to these land acknowledgements. Right?
Exactly.
So if you own fee simple property somewhere and you find yourself subject to an Aboriginal land claim and you are outraged about the fact that your fee simple title may be now undermined, and if you have ever done a land acknowledgement, well then, what are you complaining about? Because you've been saying that you live on Aboriginal land. And now that's coming home to roost. Right? The problem is that people do not take these things seriously. You got to mean what you say. And if you say that you live on Aboriginal land, well, then maybe that will just come to be.
Wow. So this is really remarkable. So even Aboriginal land acknowledgements, it's almost like it's an opening prayer now for all kinds of events.
Yeah.
Actually mean something. They aren't just theater or perfunctory. They're actually legally significant, Bruce. Like, if you keep saying that you live on Aboriginal land, you will give up your ownership.
Either way, people doing these acknowledgements are hypocrites. Either way, right? Because either they don't believe them, in which case, why are you bothering? And if you do believe it and it comes to pass and you complain, then why are you complaining?
Unbelievable. So we've got to pay attention to what is going on here. And of course, we share a common vision of living in peace and harmony with each other and prosperity. But this is almost taking the law that we thought that was there to protect our property rights. We've relied on our government decision makers, both elected and non-elected, our institutions, the law, the courts, to uphold our property rights. But something's been going on now for a long, long time to actually undermine them. That's the real story here, isn't it, Bruce?
Yes. Your governments are not to be trusted, and especially right now, and especially in BC. the BC government. So here's one of the things the BC government has done. Two things at once. We've referred to the comments of the NDP government last week. The Attorney General said, Aboriginal title is not superior to private property. Well,
Yes.
Number one, the BC government did not robustly defend the claim in the first place.
What do you mean? They sent them into the court?
Into the court.
Told
They
them
could.
not to...
They selectively defended the claim in the court. They're claiming now to want to appeal it on lots of grounds. Well, they didn't do a very good job in the first place, and that might partly be because they're doing this other agenda at the same time outside of the courtroom in making these agreements. So, I mean, you can't take what they're saying at face value. They're talking out both sides of their mouth.
Okay, so it's the actions that we should judge governments on.
Always.
And the question is, are they upholding property rights as superior, period, or are they holding up Aboriginal rights as superior and prior, as per the court decision?
Well, what they're going to try to do is insist, as they have been doing, that the two things can coexist. Which
they can't.
I mean, it's going to be more of the mushy, incoherent Canadian middle, where we never actually resolve what the story is, and we're just going to carry on and pretend like everything is fine.
Unbelievable. So how the heck did we get here, Bruce? I know you've mentioned about legal decisions, but to me, those legal decisions are symptomatic of a much deeper assumption. It's almost like the assumption is that we rest on stolen land and that the British and the French never conquered Canada.
Right.
It's almost like the assumption is that somehow Aboriginal groups were never conquered. Am I being too simplistic here?
No, not really. No. I mean, this whole thing is essentially based upon the pretense that the territory called Canada was not conquered. But of course it was, by the British and the French. And how do we know that? Well, because the British and the French were not invited, and they couldn't have been persuaded to leave. That looks like conquering to me.
Yeah.
And
we're not settlers, in other words. This is our home.
But there's a much larger point about this. And like we're talking as though there's two sides, and there were two sides at the time. Mm-hmm. There were newcomer Europeans and there were Aboriginal peoples at the time. There are not distinct peoples now. Everybody born in this country is native to the place.
Yeah,
right. And we are pretending as though there's a group of people, most people arrived from somewhere else. That's not true. We've all been here. We are all home here. And the fact of the matter is that nobody who was alive at the time that all these things happened is alive now. Everybody is gone. And everybody else is a mixture of other things, both genetically and culturally. We live in a different time and place. And the enterprise of trying to trace back, identity and connections to, which of those two groups do you have more of an affiliation with, and therefore are you victim or are you conqueror? I mean, it's ridiculous. The sign of a country, of a free country governed by the rule of law, is whether or not your laws apply equally to everybody without regard to who they are, who their parents are, what genes they carry, what group affiliation they have. Those things are not supposed to matter. And the fact of the matter is that in Canada, we've insisted that they do matter. And the first topic on which we insist is Aboriginal rights. It's not the only one. We've gone further down this road with respect to other kinds of identity politics. A terrible idea. But it's an extension, if you like, of this basic idea, which is, no, your rights and entitlements depend upon who your parents are and who their parents were and who their parents were. And I mean, we all know people who, for example, have a relative in their lineage somewhere, an aunt or a grandmother or something, who can trace their origins to an Aboriginal group, and they have a status card. Mm-hmm. They have a status card, right? They might be, if you're doing the, the genetic calculation thing, which is a terrible idea, terrible idea, but that seems to be what's happening. So if you do the genetic calculation and you say, well, I don't know, like 4/5 of your genes are this and 1/5 is that. So, but nevertheless, you get this, and it's a recipe for disaster, and we got to stop it right now. They don't do this in other kinds of countries. I suppose because their history is further back than that. But I like to refer to the UK, just as an example of this. Invasion and migration and mixing is the history of the human race. It has happened all through history, right? So if you take the UK for an example, and I'm going to simplify, of course, but, the Romans invaded Britain, 500, forget exactly when, succeeded on their second try. The Saxons conquered the place around 500 BC, and then the Normans came in 1066. Right? And Britain today is made up of people who are from all these kinds of backgrounds, right? And British law doesn't say, well, okay, your rights depend upon whether you have more Roman or Saxon or Norman in you. That would be ridiculous. Ridiculous. It wouldn't work. Yeah. But yet we are trying to do that kind of thing in this country.
And why are we trying to do this kind of definition of citizenship and your rights dependent on your hereditary lineage? Why is that happening? Is that just a direct reflection of cultural Marxism, then?
Well, yeah, you could put it that way. And in fact, it's not even so. When I make this argument, sometimes the reaction is, but it's not genetic, it's not genes, it's not lineage. And to some extent, they're right in this respect. So these groups seem to have the right to determine for themselves who gets to belong. So you can belong to one of these groups without having any, lineage to you. And the groups can also kick you out, apparently, if you misbehave, right? This is a function of a tyrannical governance system inside these communities, right? They are governed by their own elites, and this system has never been to the advantage of the ordinary rank and file Indigenous person. It is to the advantage of their leaders and elites who control the game and the money.
Right. Wow. So this seems like there's a lot of interest at play. It's not just, ideology, or it's also about power and money.
Of course.
There's a lot at stake here.
Of course it is. Yes.
So as we look at this, how do we grab a hold of this? Because one of the things that, at Frontier, we'd emphasize basic principles of good public policy like transparency and accountability. How do you empower the individual to run their lives as they see fit? But the transparency theme is very concerning here. It seems like, let's take example, the Cowichan decision. And there's so many other examples. The Haida case is an example. Among others, you've got Blood Vein First Nation in Manitoba blocking Crown land as access to licensed hunting, which is all against their own treaties. But it seems like there's a lot of parties that don't want to talk about what's really going on. Like the Cowichan decision itself, the judge did not allow the city of Richmond to have a public meeting about it. So why is that? Like, shouldn't these be transparent processes where people find out what's going on as they talk about your property and who owns it?
Yeah, you'd think, but that thinking is in accordance with the system that we used to have, and we think that sometimes we still do. And that's not the system that we now have. Our legal system has been transformed over a period of time. And, these ideas are still around. I mean, you'll still see claims of transparency and requirements for transparency. But on the other hand, transparency is really not valued like that anymore. And I'm sure that in this kind of situation, there were considerations, and probably quite valid ones, that if you make everything transparent, there's going to be backlash. And now you're getting the backlash.
Now you're getting it.
Yeah, and so they should get the backlash, right? But sometimes we assume too much about the honor of our government, our authorities, to to behave in accordance with the principles that we think apply. And some of those principles are on a very shaky ground now.
Gosh, so what do we do about this, Bruce, this situation? I mean, we've got to really pay attention here and inform ourselves. But, I mean, poll after poll shows that Canadians don't want some type of unusual, like first and second rate citizens. They want equality. That's been shown time and time again. I think people would be shocked about the implications of this decision. And we can't assume that our government officials really have our back now, can we?
No.
We've got to really do the work of being a citizen now.
Right. Yes.
Is that the answer?
Why? Yes, I think so. But let me just question something first. So there's going to be a lot of people who are upset about this decision and its consequences, and they should be. And about all the other things the BC government is doing, and they should be. But I would be curious to know, if you asked those people who were unhappy, if they agreed that there should be no such thing as Aboriginal rights in this country. I'll bet you a lot of them would say, well, we shouldn't go that far. Because this idea is so deeply ingrained in Canadian culture, not to mention the law, that it's a hard thing for people to get their heads around. But if we're thinking clearly, in my books, we have to reject the idea that there are different peoples that the law should distinguish between. That is the opposite of blind justice. It is the opposite of the rule of law. We've got along with this for a long, long time, much too long, and it is time to bring it to an end. But unless you can get, the person on the street in Canadian cities to confront that question and say, yes, you're right, the time for different status, different legal status for different kinds of people is done. We want to do away with that, and we should do whatever is necessary to accomplish that aim. Until you get there, we're going to stumble along.
Unbelievable. So this decision isn't just simply about 800 acres in Richmond, BC.
No.
This is a profound shockwave across the country about what it means to be citizens in this country, whether our economy can move forward, and quite frankly, whether we're going to grow up as a nation and be sovereign.
It's going to be interesting to see what happens on appeal, and going to be interesting to see what happens outside of the courtroom context. In this sense, it just might be the case that, and I don't know this, one can hope, but it just might be the case that this might just be a step too far for this, so-called reconciliation project, which I don't regard as reconciliation. We call it truth and reconciliation. I've come to call it fiction and capitulation. It's not reconciliation. Reconciliation is a coming together of two sides to come to a common understanding. This is not that. This is not that by any means. And so it's possible that this is just one step too far, and there might be stepping back from the edge of the cliff, if you like. But if not, well, then we're really into it.
Well, we sure are into it, Bruce Pardy, and I'm so glad that we could have this discussion today, because this is clearly a seminal moment in Canada's history. So thank you very much for joining us today.
My pleasure, David. Thanks for having me.
Here at Frontier, we don't receive any government funding. We are nonpartisan, and we work for you. Find out more and support this important work by visiting fcpp.org today.
Want more? Please hit the subscribe and check out our full episodes right here on the channel. New conversations every week. Don't miss out.